The timestamp on my settlement proposal showed 3:47 a.m., but I'd never worked past midnight on the Morrison case. I'm Archibald Norwood, 42, criminal defense partner at one of Houston's most respected law practices. 20 years defending white-collar cases taught me to spot inconsistencies. This one made my stomach drop. The document sat in my case management system exactly as I'd written it. Every clause, every precedent citation, every strategic argument I'd crafted over 3 weeks of careful preparation. But the metadata told a different story. Someone had accessed this file at 3:47 a.m. on Tuesday. I'd been home with food poisoning that entire night. I pulled up the access logs, my user credentials, my digital signature, my billable hours automatically logged for Client Morrison's account, 4 hours of work I'd never performed, on a settlement I'd already completed. The Morrison case represented 18 months of investigation. A pharmaceutical executive accused of securities fraud. The settlement proposal could save his career and spare him federal prison time. I'd structured it personally, knowing every regulatory nuance that made it viable. But someone else had been in my files. I scrolled through the system activity. The mysterious session had lasted exactly 4 hours. During that time, someone using my login had accessed Morrison's entire case file, reviewed opposing counsel's discovery responses, and apparently refined my settlement language. The billing entry showed meticulous time tracking, settlement, negotiation strategy, and proposal refinement. My hands felt cold as I checked the document version history. The proposal had been modified during that 3:47 a.m. session. Subtle changes, improved phrasing, stronger legal arguments. Someone had taken my work and made it better. The firm's case management software required biometric authentication for after-hours access, fingerprint and password. Only I had those credentials for my cases. The system showed no security breaches, no unauthorized access attempts, no failed login warnings. I opened my email to search for any automated alerts from that night. Nothing. The system had accepted whoever accessed my files as legitimate, as me. My office door was locked. My laptop had been secured in my desk drawer. The building's keycard logs would show who entered the office that night, but I already knew what I'd find. My own access card, somehow used while I was homesick. The settlement proposal now looked different to me. The language was sharper, more persuasive. Whoever had modified it understood Morrison's case better than I'd expected anyone else could. They'd improved my work while stealing my identity. I printed the access logs and document history. The trio was clear, but the explanation made no sense. Someone had perfectly impersonated me in our most secure system, enhanced my legal work, and left no trace except the timestamps that proved I couldn't have been there. My phone buzzed with a text from Morrison. "Brilliant settlement proposal. Exactly what we needed. You're a genius, Archibald." But I hadn't sent him anything yet. The Morrison case had started 6 months earlier, when Vincent Worthington walked into our Houston office claiming workplace discrimination. His former employer, a mid-sized engineering firm, had terminated him after 15 years of exemplary service. The circumstances seemed suspicious. Vincent had filed an internal complaint about safety violations just weeks before his dismissal. I'd taken the case because Vincent's story rang true. His documentation was thorough, his timeline consistent, and his former colleagues were willing to testify. The engineering firm's legal team had initially dismissed our claims, but their tone shifted dramatically after I submitted discovery requests targeting their safety protocols and internal communications. Carolyn Blackwood, our billing coordinator, had been particularly helpful throughout the case. She'd worked at the firm for 8 years, managing client accounts and tracking billable hours with meticulous precision. Caroline understood the complexities of employment law billing better than most attorneys I knew. She often stayed late to ensure our time entries were accurate and properly categorized. Vincent's case is generating significant hours, Caroline had mentioned during our monthly billing review. The discovery phase alone has exceeded our initial estimate by 40%. I'd appreciated her attention to detail. Employment cases required careful documentation of every research hour, every client consultation, every document review session. Caroline's billing summaries helped me track our progress and justify our fees to Vincent, who was paying from his severance package. The breakthrough had come 3 weeks ago, when opposing counsel's discovery responses revealed internal emails discussing Vincent's safety complaint. The engineering firm's management had clearly viewed his concerns as a threat to their upcoming contract renewal with a major client. Their decision to terminate him appeared retaliatory and legally indefensible. I'd spent 2 days crafting a settlement proposal that balanced Vincent's damages with the firm's desire to avoid public litigation. The document outlined compensation for lost wages, emotional distress, and legal fees, while including confidentiality provisions that would protect both parties. It was solid work, comprehensive, persuasive, and strategically positioned, but someone had accessed my files and improved it. I called the building's security office to request keycard logs for the previous week. The guard, a retired police officer named Marcus, pulled up the electronic records on his computer. "Your card was used Tuesday night at 11:43 p.m., Marcus said, scrolling through the data. "Exit logged at 4:15 a.m., long night counselor. I wasn't here Tuesday night. I was home with the flu." Marcus frowned at his screen. "Card shows normal entry and exit. No alerts, no forced doors. System logged it as routine access." I thanked him and returned to my office, my mind racing through possibilities. Someone had cloned my keycard or somehow obtained my credentials. But the biometric authentication required my actual fingerprint. The firm's security system was state-of-the-art, installed after a competitor had attempted to steal client information 2 years earlier. Caroline knocked on my doorframe. "Archibald, do you have a moment? I need to discuss Vincent Worthington's billing." She entered carrying a thick folder and her laptop. Caroline was 34, efficient, and had never given me reason to doubt her integrity. She'd helped me navigate complex billing issues on dozens of cases. "I've been reviewing Vincent's account," she said, opening her laptop. "The settlement work you completed Tuesday night pushed us over our budgeted hours. I wanted to confirm the time entries before sending the final invoice." My stomach dropped. "What settlement work?" Caroline looked confused. "The proposal refinement. You logged 4 hours of settlement strategy and document preparation. The timestamp shows 11:47 p.m. to 3:51 a.m. I stared at her screen. The billing entry was there, detailed and professional. It described exactly what someone had done to my files that night, reviewing discovery materials, analyzing opposing counsel's position, and refining settlement language. "Caroline, I wasn't here Tuesday night. I was sick." Her face went pale. "But the billing entry, it's in your name, with your login credentials. The system shows you accessed Vincent's files and worked on the settlement proposal." I turned my computer screen toward her, showing the document version history. Someone modified my work while using my identity. They improved the settlement language and left a perfect billing trail. Caroline studied the timestamps, her expression shifting from confusion to concern. "This is impossible. The system requires your fingerprint for after-hours access. No one else can log billable time under your name. Unless they had help from someone who understands our billing system." The words hung between us. Caroline's face flushed as she realized the implication. She'd been the one to bring up the billing discrepancy, the one who'd noticed the overnight work session, the one who understood our security protocols better than anyone. "Archibald, you can't seriously think I—" "Show me your access logs for Tuesday night." Caroline's hands trembled as she pulled up her own system records. Her keycard had been used to enter the building at 11:35 p.m., 8 minutes before mine. Her exit was logged at 4:22 a.m., 7 minutes after the mysterious session in my office had ended. "I can explain this," she said quietly, "but I was already reaching for my phone to call the managing partner." Caroline Blackwood had been stealing my work, using my credentials, and billing clients for her. unauthorized access to confidential files. She'd been doing it for months, maybe years, perfecting other attorneys' work while building a secret portfolio of legal strategies and client intelligence. The settlement proposal that had impressed Vincent so much wasn't entirely mine. It was a collaboration I'd never agreed to, with someone who'd been betraying my trust while I praised her dedication and attention to detail. Caroline stood slowly, her laptop clutched against her chest. "You don't understand what you're accusing me of." "I understand perfectly. You've been using my identity to access client files and improve my work without authorization. That's identity theft, unauthorized practice of law, and breach of client confidentiality." Her composure finally cracked. "I was helping you, making your work better, making the firm more successful, by stealing my credentials and violating every ethical rule we're bound by." Caroline's eyes filled with tears, but her voice remained steady. "I've been doing this for 2 years, Archibald, 43 cases. Every settlement I've touched has exceeded client expectations. Every brief I've refined has strengthened our arguments. I've saved this firm from malpractice claims you'll never know about." The confession hit me like a physical blow. 2 years, 43 cases. Caroline had been living a double life as an unauthorized attorney, using stolen credentials to practice law without a license, while billing clients for her illegal services. I stayed after hours to proof their class action filing, and that's when I found the pattern that would destroy everything we'd built. The managing partner's office felt smaller at midnight. Vincent Worthington sat behind his mahogany desk, reviewing the I'd compiled, while Caroline waited in the conference room, under security supervision. 2 years, Vincent said, scrolling through the access logs on his tablet. 43 cases. She's been practicing law without a license using your credentials. The billing records show she charged clients for unauthorized legal work. That's fraud on top of everything else. Vincent's jaw tightened. How much are we talking about? Conservative estimate, $230,000 in fraudulent billing. But the malpractice exposure could be millions if clients discover their cases were handled by someone without legal authority. The conference room door opened. Caroline entered with her attorney, a criminal defense specialist from across town. Her composure had returned, but dark circles under her eyes betrayed the stress. "Ms. Blackwood," Vincent began, "you've admitted to unauthorized practice of law, identity theft, and billing fraud. Do you understand the severity of these charges?" Caroline's attorney leaned. "My client was attempting to assist the firm's operations. There was no intent to defraud." "Intent?" I pulled up the billing software on my laptop. "She created false time entries under my name. She accessed confidential client files without authorization. She submitted legal documents using stolen credentials." The key was overwhelming. Caroline had developed an elaborate system of credential theft, using my login information to access case files after hours, then billing clients for her unauthorized legal work. She'd even forged my electronic signature on settlement documents. "The state bar will need to be notified immediately," Vincent said. "This constitutes unauthorized practice of law," Caroline finally spoke. "I have a law degree from South Texas College of Law. I passed the bar exam 3 years ago. I just never completed the character and fitness review." The revelation stunned the room into silence. Caroline was technically qualified to practice law, but had been denied admission to the bar for undisclosed reasons. She'd been working as a billing coordinator while secretly practicing law using my credentials. "That makes this worse," her attorney said quietly. "You knew exactly what you were doing." Over the next week, the investigation expanded. The Office of Disciplinary Review launched a formal inquiry, led by Forensic Audit Director Amber Steele. Her team discovered Caroline's scheme extended beyond simple credential theft. She was running a shadow practice, Amber explained during our interview. "Using your identity to provide legal services while billing clients through the firm's accounts. This is sophisticated fraud." The forensic audit revealed Caroline had been intercepting client communications, responding to emails using my credentials, and even attending client meetings while claiming to represent me. She'd built relationships with clients who believed they were working directly with a licensed attorney. The malpractice implications are staggering. Vincent told the partnership during an emergency meeting. Every case she touched could be grounds for a legal malpractice claim. The partners voted unanimously to terminate Caroline and cooperate fully with the criminal investigation. But the damage was spreading. 3 clients had already filed complaints with the state bar after learning their cases had been handled by an unlicensed practitioner. Caroline's criminal trial began 6 months later. The prosecution presented overwhelming of identity theft, fraud, and unauthorized practice of law. Her defense argued she'd been trying to help the firm, but the jury saw through the manipulation. The defendant systematically stole Mr. Norwood's professional identity, the prosecutor argued. She billed clients for legal services she had no authority to provide. This wasn't assistance, it was fraud. The verdict came back guilty on all counts. Caroline received 18 months in federal prison and was ordered to pay restitution of $230,000 to the firm's clients, but the professional consequences extended beyond criminal court. The state bar's disciplinary hearing was devastating. Caroline's application for bar admission was permanently denied, and she was prohibited from working in any legal capacity. Ms. Blackwood demonstrated a fundamental lack of integrity, the disciplinary panel concluded. Her actions violated the core principles of legal ethics and endangered client interests. The firm faced its own reckoning. Vincent implemented new security protocols, requiring 2-factor authentication for all case management systems. We hired a compliance officer to monitor billing practices and credential usage. I testified at 3 separate malpractice hearings, explaining how Caroline's unauthorized work had affected client cases. Most settlements were resolved quietly, but the firm's reputation suffered. 2 major corporate clients terminated their relationships with us. The personal toll was harder to measure. I'd trusted Caroline completely, praised her dedication, and recommended her for advancement. Her betrayal forced me to question every professional relationship I'd built. During the final disciplinary hearing, Caroline addressed the panel directly. I believed I was helping. I thought my work was making the firm stronger and serving clients better. I was wrong. Her words felt hollow after months of investigation and testimony. The damage was too extensive, the betrayal too calculated for simple regret to matter. The state bar issued its final ruling on a cold December morning. Caroline was permanently barred from legal practice in Texas and faced additional sanctions in other jurisdictions where she'd attempted to work. Vincent called me into his office that afternoon. The partnership has voted. We want you to head our new ethics compliance division. Your experience with this case makes you uniquely qualified. I accepted the position, knowing that Caroline's betrayal had fundamentally changed how I approached legal practice. Trust would never come as easily, but vigilance had become second nature. The last piece arrived 3 weeks later. Caroline's personal laptop, seized during the investigation, contained drafts of legal briefs for cases she'd never been assigned. She'd been preparing to steal more work, expand her unauthorized practice, and potentially leave the firm to start her own illegal operation. The scope of her ambition was breathtaking and terrifying. Caroline hadn't just stolen my work. She'd been building towards stealing my entire career. 6 months later, I stood in the conference room of my new practice, reviewing case files with a clarity that had taken months to develop. The betrayal had taught me to read between every line, question every assumption, and verify every detail twice. My solo practice specialized in legal ethics consulting and malpractice defense. The irony wasn't lost on me. Caroline's theft had created my new career path. Attorneys facing disciplinary action sought my expertise because I understood both sides of professional misconduct cases. The Houston legal community had absorbed the lessons from Caroline's case quickly. 3 other firms had discovered similar unauthorized work by support staff, leading to industry-wide policy changes. Background checks became more thorough. Access controls tightened. Billing systems added verification layers. I work with law schools to highlight ethical risk cultures and help students recognize warning signs before they enter practice. The presentations always drew packed auditoriums. Young attorneys understood that trust without verification could destroy careers overnight. Vincent called occasionally to update me on the firm's recovery. They'd implemented new protocols, hired additional compliance staff, and rebuilt their client relationships through transparent communication. The partnership had survived, but barely. Caroline's criminal trial concluded in March. She received 18 months in federal prison for wire fraud and identity theft. The judge noted that her actions had undermined public trust in the legal profession itself. Her sentence included full restitution to affected clients and permanent prohibition from any legal adjacent employment. The personal healing took longer than the professional recovery. I'd learned to compartmentalize the betrayal, treating it as a case study rather than a personal wound. The analytical approach helped, but some nights I still wondered how many warning signs I'd missed. My new office overlooked downtown Houston, the same skyline I'd watched from the firm's windows for 8 years. The view reminded me daily that careers could be rebuilt, trust could be earned again, and vigilance was the price of professional integrity. The final insurance settlement arrived on a Tuesday morning. The check represented closure for the last affected client, the throw of a paper trail that had consumed 18 months of investigation and litigation. I deposited the check, updated my case files, and locked the Caroline Worthington folder in my secure cabinet. The investigation was complete. The consequences had been served. The lessons had been learned. It was finally over, and the silence felt earned.